Hey, it's Liran from Aliav Law, here to talk to you about why you should never put your children's name as a joint tenant on your property. People do this because they know that it's a cheap alternative to a trust or a will, because the person listed as a joint tenant, so if joint tenancy just means more than one person owns it and it has joint tenancy in the name, that will make the other person inherit the property right after death. And so a lot of people like to do this and think that, you know, all is well when they do this. I'm here to talk to you about why you should never, ever do this. The first reason is because of taxes. There's something called the capital gains tax, which means that there's upon sale, this is a tax upon sale. The tax man wants to see how much richer you've gotten since when you bought it and then tax you on that. And it only happens upon sale. So if you buy something for 100 and then sell it for 500, you have a 400 gain. And taxman wants 20% or whatever your tax rate is of this $400 gain. There is a special provision, and this is a bonus from the government. They don't give many bonuses out, but this is one of them, is something called the step up in basis. And a lot of people have no idea what this is, but I'm here to talk to you about the step up in basis and how amazing of an opportunity it is for you and your family to take advantage of this. So if you pass away, remember we had that $500, $100 problem with the 400 gain. If you pass away without selling and you hold the property and then you give it to your children, you could take advantage of something called a step up in basis, which means that this 100 rises all the way up to the date of death value. So if you sell one day later, there is no capital gains. Zero. You've eliminated all of those taxes just by holding on to the property. And a lot of people make the mistake of selling the property before they pass away to help with medical costs, which is a big no-no, and I'll talk to you about a reason why you shouldn't do that in another video. But this step up in basis, when you have a joint tenant, is not going to be a full step up in basis. So you're going to end up, the inheritor will end up getting the property just like you wanted. And then what happens? They sell and there's a huge tax, which could have been completely avoided had you done proper estate planning. So reason number one not to do this is the step up in basis is lost when you do a joint tenancy. It is lost for the complete 100% step up in basis. So that's the first reason. The second reason is when you put someone in as a joint tenant, you are effectively making them your partner, a 50% owner, which means that if there's a lawsuit against them, they could take your property. Did you want that? Did you intend to do that? These are questions you have to ask yourself. And similarly, if there's a lawsuit against you, they could take his property. It's the same thing. They are both on title. Both people are subject to creditors, and there is absolutely no protection for that. A third reason, I know I said there was two reasons, is you may lose the 121 exclusion, which means that the law affords you a $250,000 capital gains bonus, meaning that if you bought it for 100 and then sold it for 350 and you're a single person, that $250,000 of gain is effectively out and you don't have to pay capital gains tax. And if you're married, it's $500,000. But that could also be lost if you have a joint tenant, and depending on who lives there and how. So you should really make sure to have advice before you do something like putting your child in as a joint tenant. Whether it's property, whether it's stocks, it could be the same issue. So again, this is Liran Aliav from Aliav Law. And if you have any questions, just shoot me a comment below or give me a call. Okay, if you enjoyed the video, your next step is to sign up for the webinar by clicking the link above. If you have any questions or concerns, go ahead and comment below. Be happy to address them. See you soon.